So let's talk about real estate in the state of South Carolina. In the state of South Carolina, we actually have a document called an agency relationship document. And it's to let you know how you're being represented in a transaction. And according to South Carolina state law, it says that we must actually present this to you and give you a meaningful explanation of it and the scope of our services at first meaningful contact. Now, here's what we also know is that there are several different ways to represent you in the state of South Carolina. Number one is that we could not represent you and we could represent another party in the transaction. That is what we call a customer. As a customer, let's say that you are a buyer and you're looking to purchase a home and you are a customer, that means the agent is representing the seller. As a customer, our job is to present all offers in a timely manner, account for money received on your behalf, be fair and honest, and disclose any adverse material defects that we may know about the property. Now, at that point, as a customer, we cannot help you, give you advice, can't give you counsel. We do not owe you obedience. We do not owe you loyalty. As a customer, we do not owe you those items. It's strictly present all offers in a timely manner, account for money received on your behalf, and be fair and honest and disclose any adverse material defects that we may know about the property, and also to account for any money that was received on your behalf. Now, the other way that we can represent you is as a transactional brokerage. And transactional brokerage actually means that we don't technically represent either party against the other party in the transaction. What it actually means is that our job is to represent the transaction to get it to the closing. We can't offer advice, counsel, or assistance in negotiations to either party. And then we have what's called a customer, or excuse me, as a client. A client, we actually represent under contract to get them, know them, what we call OCAR: obedience, loyalty, disclosure, confidentiality, accounting, and reasonable care and skill. It also means that we owe you advice, counsel, and assistance in negotiations. With advice, counsel, and assistance in negotiations, obviously, those are the big ones that most people believe that they are receiving when they employ the services of an agent. Yet you do not get those unless you have actually signed an actual buyer's agency agreement or an exclusive right to sell agreement in the state of South Carolina. Now, as a client, there's actually two different ways to represent you. One is single agency. Single agency means that I represent my client under contract to get them the best price and the most favorable terms, and the agent that is representing the other party is working to give that client the best price and the most favorable terms. We will negotiate against each other, no problems. Now, the other way that we could represent you is by dual agency. In dual agency, there's actually two different types in the state of South Carolina of dual agency. There is a dual agency, which is disclosed dual agency. That means that I personally represent you under contract to get you the best price and the most favorable terms. And I or someone on my team represents the other party, either the buyer or the seller, to get them the best price and the most favorable terms. The actual document says that this is a conflict of interest, even though our state allows it, our brokerage allows it, and that being said, both parties would need to sign stating that they are okay with that, separate from their buyer's agency agreement or the exclusive right to sell. Now, the other way to represent you is still a dual agent type. It's a little different. It's called designated agent. Designated agent means that I represent you under contract to get you the best price and most favorable terms, and another agent is representing the other party, either the buyer or the seller, to get them the best price and the most favorable terms, and that agent is actually in my brokerage under the same brokerage as myself. Now, me and that other agent, we can negotiate against each other, no problems. The only difference is that our broker in charge cannot give any advice to harm either party during negotiations. So at that point, me and the other agent will negotiate against each other, yet the broker in charge cannot give any advice to harm either party during negotiations. They have to remain neutral. Now, when an agent presents this to you, they are going to ask you to sign it. It is not an actual agreement. It actually states on there that this is not a contract. It is you are strictly signing that we did give it to you and we gave you a meaningful explanation of it. So I hope this helps in understanding the different types of agency relationships that we have in the state of South Carolina.